I'm Abbott, and I'm Chairman of the Australian SMSF Members Association, or better known as ASMA. Now, one of the most important engagement things we're going to look at, and this comes up as benefit number 7, is what to do in the event of your death inside that fund. Unfortunately, many people are still relying on really old law which deals with doing a binding death benefit nomination inside a self-managed super fund. There's been a case, Donovan and also a Commissioner's ruling, which basically says the law that provides the ability to do a binding death benefit nomination only applies to industry and retail funds. In order to determine what you really want to do in terms of passing out your wealth, and I'm going to give a couple of strategies around this in terms of self-managed super fund, what you need to do is focus back on the trust deed. And it's absolutely crucial that you do get a really good trust deed. All the strategies I've been talking about are immaterial if you've got an old deed. And by an old deed, I mean something that predates 2010. You need to update your deeds at least every couple of years because the laws change that much every couple of years. As I said, binding nominations and also the latest borrowing rules, they weren't around in 2010. You know, there's been changes to cases, so you've really got to be focused in on that. Anyway, getting back to our estate planning. Remember in the last instance when I was talking about taxing the fund, we had two sides. We had an account, we had effectively our accumulation fund and also our pension side. Remember the 15% and also the zero side. Well, this is the way it works. If you die when you're still in the accumulation side, you need to plan for it. If you don't plan for it, the trustee of the fund generally has complete discretion as to what they want to do, and that's not a good place to be. So what we want to do is we want to sit down, we actually want to start to make a plan in relation to what happens there. And we can set down a set of binding directions to the trustee. It's like a contract between you and the trustee of the fund or the future trustees of the fund. This is what I want to happen in terms of the event of my death. Now, what a number of practitioners call it, is something so you can get a good understanding of it, they call it an SMSF will, which is just simply a set of binding directions that deal directly with your super benefit for that money to be passed out according to your wishes to your dependents or accordingly over to the estate. Now, the benefit of paying it directly out to your dependents, and dependents in this instance include your children, anyone who's financially dependent upon you, and of course your spouse. The ability to pay it out directly is that it can't be challenged at law. If you pay monies out to the estate, effectively there can be challenges or attacks on that superannuation money under various Family Provisions Act. Be careful though, each state has its different benefits, so you probably want to see a really good SMSF estate planning lawyer to make sure you're doing the right thing. But effectively, we want to pay out an SMSF will. It's a great opportunity, set of binding directions, much the same as a will outside the fund. If you've simply looked after your superannuation, your will outside the fund means absolutely nothing. Everything must be done through your superannuation trust or your self-managed superannuation fund. So accumulation side, SMSF will. On the pension side, it's different. Once you start to commence a pension for yourself, the way to do it is not to set up an SMSF will, but rather inside the pension documentation or when you establish it, what you want to do there is make sure that it passed the parcel. You pass it on. So it may go from dad to mum, and we call this an auto-reversionary pension. It's estate planning built into that income stream, into that pension. It goes from dad to mum, and then if there's children alive and children are under age 25, and they're financially dependent, it can then go to the children, or alternatively it can go dad to mum and then on to the estate to look after the children. Again, it may be subject to challenge at that point in time, but you want to pass the parcel as fast as you can go. Again, go and have a look at the ASMA website, www.smsfmembers.com, or simply search for me on Google, Grant Abbott or SMSF Strategies, the firm that I work for. There's quite a lot on auto-reversionary pensions and estate planning. But again, it's a really key principle there for us, a great benefit. These are all these sort of things that aren't available in industry or retail funds. You certainly can't get a reversionary pension in an industry or retail superannuation fund. The final one, and I'm just going to put it to you, unfortunately, I'm a baby boomer. People born between 1946 and 1964, as many of you watching this may well be. If you're a younger generation, well, your parents probably going to be baby boomers. We're in that invidious position that by the year 2030, there's expected to be 1 million Australians who will suffer from dementia, which really, for a lot of purposes, may well be Alzheimer's. They won't have the capacity to look after their own affairs inside the fund. which is all very well. What we've got, and particularly again if you're using a good deed, what happens is if you lose your mental capacity, you can find your executor or the person who has your enduring power of attorney. And it's important, if you're getting engaged and you want to make sure you have one of these funds, to have someone with an enduring power of attorney. If you want to do that, your person with your enduring power of attorney can effectively take over your trusteeship or your directorship if you've got a corporate trustee. Again, the way that I said is the preferred methodology of having trustee. So they'll take over, but importantly from that perspective, if they're taking over, they're taking control, you've got no capacity, they're looking after your affairs, you haven't given them any guidelines, you haven't given them any directions, and more importantly, you're giving them full discretion as to what they want to do with your monies. They can pay it all out to themselves if you're over age 60 and effectively look after your needs outside of super. They can close your accounts inside the fund. So what we've done is we've come up with certainly there's a number of practitioners and I'm for one, and I've done quite a bit on this. Again, go to the YouTube channel on what to happen in the event of dementia. What we've put in place is, again, much the same like benefit number 7, where we leave a set of binding directions in the event of our death. What we do is we now leave a set of binding directions in the event of our death to our enduring power of attorney. It means they have to look after us in a certain way, shape or form. They can't just simply close our account and have full discretion as to what to do. We call this, again, just for ease of terms of reference, an SMSF living will. One is that it has capacity, first off, to make sure there's an appointment of your enduring power of attorney to take over as your trustee. So that's the first thing. And then is also to say, well, really, we want to continue our income stream if we've got it. We want to make sure it meets our living needs. If we need to get an aged care place, it's going to meet those sort of needs as well. Also prevents them from taking a lump sum and using it for their own purposes. Again, it's just a contract, it's something to be safe, and sometimes it's better in terms of family situations or external people acting as enduring powers of attorney. Sometimes it's better to be safer than sorry. And so that's the 8th benefit for a self-managed super funds. So we've been quite through a lot here to really get your mind around it, but I take you again back to that first benefit, which is the engagement. If you're going down this track, I've just given you a little potted summary on each of these benefits. There's a whole lot more to read, a whole lot more strategies around that. I've only given you one strategy, and that was talking about the tax and the fund. There's hundreds of different strategies, little nuances in the law, really great opportunities sitting there that's absolutely crucial to look at. Get yourself a really strong advisor, someone who's got a lot of clients in this area. There's now a number of professionals that have come from the accounting, financial planning profession, or even legal profession, who simply just do self-managed super funds. That's their bread and butter. And let's face it, it's such a huge sector. By the year 2018, it's expected to hold $1 trillion of assets, a large part of Australia's wealth. So because it's a large sector, make sure you get a good specialist, someone who can help. But don't expect them to know your family circumstances. What I always say to people is make sure you learn as much as they do. Go and buy the books. I've got a number of books on self-managed super funds. Go and have a look at them. You can go to www.cch.com.au or just do a search. There's a lot of material, there's a lot of good education providers there. And as I said, if you're part of the SMSF Members Association, we provide a lot of education, a lot of videos, a lot of articles there for you. Anyway, it's Grant Abbott, Chairman of the Australian SMSF Members Association, talking about the 8 benefits of self-managed super fund. If you're looking at moving over, be very careful, get advice. If you're inside a fund, if any of these things are of interest to you, make sure you go and have a chat with your advisor around them. There's some great opportunities out there, but again, as we've seen by all governments, opportunities aren't open-ended. They only last a short period of time. Get in, set yourself up, get engaged, and really make this fund a strong family superannuation fund.